criminal defense attorney, Neil Rockheim.
Welcome to another edition of Killer Cross-Examination. This is your host, Neil Rockheim. I want to spend some time talking about a phrase that I know you all have heard before. We've all heard the phrase, ignorance of the law is no excuse. I say that because for as long as I can remember, it has been a declaration by authorities, from people in high school, teachers, counselors, to people in college, to school administrators, all the way through any system you find, all the way up to the actual legal system with judges and prosecutors who've banged the table and banged the drum over and over and over again when we, in defense of some citizen or person, or perhaps you, say he didn't know. She didn't know that she couldn't do that. He didn't know that that was a law. He didn't know that that was what a particular local ordinance in the city in which she lives states is illegal. And what we get pushed back in our faces, ignorance of the law is no excuse. And you know what it should be? Spent some time over the course of the last week thinking about all of the laws, and I started flipping through, in Michigan in particular, started flipping through the Michigan Legislative Code. And I started looking at the number of statutes that have been enacted. Did you know that on average that between 2014 and 2017 that the groups were actually studying the Michigan legislature, that between 2008 and 2013, the legislature created criminal statutes at a rate of 45 crimes per year. 44% of those laws were felonies. That means that every single year from 2008 to 2013, the legislators in Michigan and the Michigan House and the Michigan Senate were creating new laws, creating new felonies. You tell me who's sitting there and who's literally, what citizen is sitting there and able to keep up with the legislators' votes on statutes, the changes that go from the House when it's proposed, or the Senate when it's proposed, to review committees, to when it's ultimately passed and signed by the governor. That's 45 new laws a year, and that's just in the Michigan legislature. Not to mention when laws are passed on a federal level, and not to mention when laws are passed in each of our own cities and villages and townships. That's a staggering amount of laws. Staggering. It's simply impossible for people to keep track and to keep up. It's actually turned into a phrase that certain people use to describe this phenomena, which is the phenomena of overcriminalization. Can you believe that there's actually a phrase for this craziness? Overcriminalization. What essentially happens is, which I've had to explain to clients from time to time when they've come to visit me in our office, I've had to explain to them that what happens is there's a tragedy, or there's an event, or there's a calamity, or there's a problem, and it gains some notoriety somewhere, and some legislator decides that he's going to put his name on it, and he's going to call it so-and-so's law or something, and come up with a fancy acronym to describe the law. And then what he's going to do is he's going to come up with the acronym, and he or she is going to propose the law, and they're going to pose the law as a reaction to whatever the calamity, the problem was. And that is happening, and was happening between 2008 and 2013. That was happening at a rate of 45 new felonies per year. Who in the world can keep up with all of that? How are we supposed to govern ourselves when the legislature in Michigan, and forget about it at a federal level, but when they're passing new laws at almost one per week? We're not talking about laws that are what we would call in law school malum per se, which are things that are inherently illegal, immoral, or against societal standards. We're talking about laws that were passed to prevent like some problem, where somebody one day went to sleep, or for example, when someone left the country on a Thursday and returned 14 days later, and what was the law on Thursday, the day that they left, and when they returned is all of a sudden now illegal. 14 days later, things have changed because the legislature went out and passed an emergency bill or an emergency law and the governor signed it. It's virtually impossible to keep up. That is a dizzying pace. And unfortunately, what should be the case, as I see all too often, is whether a person intended to break the law, whether they intended to violate the law, whether or not their conduct was willful. Did they go about the process of, when they were committing the act, say, I intend to break this law? That should be the state of our laws. I intend to do this, or I intend to do that. The question we should be asking is, did that person intend to do it, or did they act reasonably? Did they act in good faith, believing that their conduct was not a violation of the law? And I say that because over the last several years, what has developed in our law is an imbalance. What I have noticed time and time again as I meet with people and talk to them about their cases and prepare to defend them in cases is many of them had no intention to break the law. Many of them had no idea that they were breaking the law. For example, there's a case in which an individual in the state of Michigan actually walked out of his house, started his car in the cold, had his car running, and a police in his own driveway, and a police officer pulled up, and the police officer saw that the car was running and gave that person a ticket for unintended car, for having a car operating or running or in operation or on while unattended. And of course the guy said, well, it was cold, I was trying to get the car warmed up and the car heated up. But the police officer said, well, you had the car unattended. Right at that exact moment in time, there was a debate raging in the Michigan legislature, in the Michigan Court of Appeals and Michigan Supreme Court, about whether or not a person's driveway, whether your own driveway was a place in which you could be accused of violating the motor vehicle code. I want to emphasize that again. So many people believe that their driveways, I can move my car if I'm drunk, or I can let my kid drive the car in my driveway because it's my property, and my property, it's my castle, and this is my place, my little corner of the earth, and I control what happens here. And at that exact moment in time, while the vast majority of people, nearly everybody I know, believe that they could decide who, what, where, and when they did with their vehicle, and whether or not they were drinking, or whether or not their child drove their car, whatever it was, they were in control of their own driveway. The Michigan Court of Appeals was deciding a case in which a person was actually arrested and prosecuted for drunk driving in their own driveway. He, of course, believed, like the rest of us, that he could do that. Because it makes perfect sense. It's reasonable to believe that you could move your own car in your own driveway, regardless of how many beers or cocktails you've had. But some police officer was there, made an arrest, and then they litigated in court, not whether or not that person's belief was reasonable, but they litigated in court whether or not the statute that says that places that are like open to the public or places where cars can be parked, whether that statute included a person's own driveway. And so here's this guy who's accused of drunk driving in his own driveway, who reasonably believed, as we all would and could and should, that that's my driveway, I can do what I want in it. And some police officer decided to arrest him and prosecute him, and the Court of Appeals and Supreme Court ultimately decided against the person, saying that yes, you could be prosecuted for drunk driving in your own driveway. That your driveway is not beyond the scope of the statute. And so here this poor man ends up being prosecuted because despite his reasonable belief, after the fact, the law was interpreted against him. And while that case was being litigated, this other guy that I mentioned a few moments ago, who walks out of his house to start his car in the winter and lets it run, he gets a ticket. And of course he says, hey, I shouldn't get a ticket. I let my car run to warm it up in my own driveway. It's perfectly reasonable. How would I know that the motor vehicle code applies to my own driveway? And while because that other case was being litigated, that person who had decided to warm up his car, of course, his belief was just as reasonable. And the law at that time had yet to be interpreted, except when the first case was decided, the second case got decided against that man as well. And what's developed over the course of time is that we have people who act, and they act in good faith, and they act reasonably. And then the courts, some police officer or prosecutor interprets the law or statute to prohibit that activity. And instead of arguing about the reasonability of the citizen's conduct or arguing about whether or not the citizen acted in good faith, the prosecution says, well, the law prohibits that, and ignorance of the law or unawareness of the scope of the law is no excuse. So that means that citizens are not only held to know what the laws say, all of them, everywhere, but they're also held to know what and how Court of Appeals and the Supreme Court has decided these cases. That means that you have to be aware as a citizen of not only the laws, but how they've been interpreted in both the Courts of Appeal and the Supreme Court. It's simply impossible. And the inequity and the imbalance that's developed over the course of time is that the U.S. Supreme Court has actually reached a contrary rule for police officers. You won't believe this. So while you or I are held to the standard that we have to know what the law says, and that mistake of fact or mistake of law is not a defense, or ignorance of the law is not a defense, the police have it just the opposite. If they prepare a search warrant and have a judge sign it, even if the search warrant is found to lack probable cause, as long as the police officer acted in good faith, the search warrant stands. So while you could actually act reasonably and in good faith, believing that your conduct was lawful, you could still be prosecuted. And they'll say ignorance of the law is no excuse. The fact that you were unaware doesn't excuse you from having a potential crime attached to you and your life ruined or altered in perpetuity, and your rights affected or taken away or possibly even felonized or jailed. But a police officer who seeks to have evidence admitted against you in court, well, he can be wrong, as long as he went to a magistrate and had the magistrate sign a search warrant, as long as he acted in good faith. So even though our Supreme Court said, even though our Constitution says that the officer can only obtain a search warrant, and search warrants should only issue based upon a probable cause, as long as the officer acted reasonably and in good faith, the search warrant stands. So the officer can be wrong if he acted in good faith, but if you acted in good faith, you can't be wrong. The officer can actually, in preparation of a search warrant, he can have the wrong information, wrong addresses. He can name the wrong people. He could actually have an informant, and he could be mistaken about the informant's credibility or reliability, as long as he did so reasonably and did so in good faith and didn't lie or wasn't in reckless disregard of the truth. So if he was told something, he can rely on it, even if the person that told it to him turns out to have been wrong or mistaken, because the officer acted in good faith. You see the imbalance here? Do you see how it's so difficult for people to act? Because the police officers who are supposed to be enforcing the law, the officers are actually allowed to make mistakes, to be even mistaken about facts, to be mistaken about whether they had probable cause, to be mistaken about whether they should have applied for a search warrant, to be mistaken about so many things. And as long as their mistake was reasonable, the evidence comes in. As long as they acted in good faith, the evidence comes in. People want to know why there's currently some amount of rebellion against the law enforcement community. Maybe it's because of this sort of stuff. Someone would think that I have a CPL. So, of course, if you have a CPL, that authorizes you to possess a gun, but you can actually be charged with possession of a gun during the commission of a felony, despite having a CPL. If you're arrested, for example, for third offense drunk driving, which is a felony, or you're charged with some other felony. So even though you had your gun pursuant to your CPL, if you're charged with the felony and you possess your gun, the prosecution can charge you with the felony and charge you with possession of a gun during the commission of a felony, which gets you an automatic 2 years in prison. So even though you possessed a gun believing that it was lawful and believing that you weren't committing a felony, you could be charged with 2 crimes. And what happens is that the Supreme Court actually said that excused a police officer's ignorance of the law. So you think to yourself, wait, so of course maybe the police could be mistaken about a little detailer here, but what if a police officer actually arrests me or stops me believing that something was against the law and it turns out he was wrong? In other words, the person who's sworn to know the law and enforce it was wrong about the law. So you've got police officer A following somebody and says, I'm going to pull him over because he didn't use or was surveilling somebody and watches him pull out of a parking lot, which was an actual case of ours, and the person, our client, didn't use a turn signal to pull out of a parking lot. And the officer stopped our client, saying that he stopped him because it was illegal to turn without using your turn signal. And we researched it, and that wasn't the law. And we pointed out that that wasn't the actual law. So the officer who's supposed to enforce the law, who's supposed to know the law, who came into court in my questioning and admitted that he knew what the law was, and then when I put the law before him, he goes, oh, well, I guess I was wrong. What did the prosecution argue in that case? That the U.S. Supreme Court has said that that officer's conduct was permissible. Why was it permissible? Why did the evidence still come in, the prosecutor said, despite my cross-examination of the officer? Because the officer acted in good faith. And the officer acted reasonably. The officer reasonably believed that that was the law, but he was wrong. Can you believe the absurdity of this? So a person could literally think to themselves, I don't need to use a turn signal here. And if the law said you did, your ignorance of the law is no defense. You can get stopped and you can get issued a ticket. But if you don't need to use a turn signal and you don't use one, and a police officer pulls you over believing that the law required it, that stop is legal. Do you see the imbalance here, the inequity? The law has gotten to the point where we actually permit the police to be wrong. We permit them to be mistaken. And we still let evidence in. But we're people who are like the rest of us, you and I, when we don't know what the law is, or we reasonably believe or in good faith believe that the law allows us to do something and it turns out that it doesn't, we can still be prosecuted. We can't even come to court and say, I acted reasonably and I acted in good faith. Folks, this has got to change. We can't keep going like this. I can tell you time and time again, as I develop defenses for clients and we put together cross-examinations on behalf of clients, I can tell you that time and time again, I've had clients sit in my office and share with me how they thought that what they were doing was legal. They believed that what they were doing was all right. And they asked good questions like, how can this be the case? How can they do this to me? How can it be when I point out that the police officer was mistaken and was wrong about the law, or applied for a search warrant based upon almost no facts and got facts wrong, and I then have to look that person in the eye and say, the law currently is that if the court concluded that the officer acted in good faith, they don't need to have been right or correct. People look at me and they're like, I don't understand. How can that be? And it's because we've gotten so far away from just some common principles. The legal system should not be about the police officer. It should not be about should not be about admitting evidence in all cases. The goal should not be about whether or not the police acted reasonably. And you know what? The law should be equal. It should be about that if a citizen reasonably and in good faith believed that his or her conduct was lawful, that should be a defense. If that's not a defense, then no police officer should be excused when they apply the wrong law, the wrong facts, or apply and obtain a search warrant for someone's home based upon a lack of probable cause or misinformation. The legal system is supposed to be about the individual, and it's supposed to not be about prosecuting people. It's supposed to be about protecting individuals from prosecution and conviction absent overwhelming evidence. And where there's any doubt at all as to whether or not a person intended to break the law, no person should be convicted. So we've got to get back to a system that's based on the accused. We've got to get back to a system that favors the accused. That's the way it's supposed to be. It's supposed to be about whether or not the accused intended to break the law. That's the criminal mindset. Not whether he or she did something that turns out later to have been interpreted as criminal. It's supposed to be whether or not you acted with criminal intent. And if you didn't act with criminal intent, then you shouldn't be treated any differently than the police officers who come to court and say that they acted in good faith. What's good for the goose is good for the gander. This has just got to be where we get back to. We have to get to this point. There are simply too many laws. We're making up words that describe it. Overcriminalization. Too many laws, too many interpretations, and too many interpretations by higher court after higher court for common everyday lay people to follow. And if the police can't keep up, how can we expect individual citizens like you or me to keep up? We can't. This is Neil Rockhind. This is another edition of Killer Cross-Examination. Subscribe, like, follow, and please pay attention to what you're doing. Because as I pointed out, right now, the law is not in your favor.
Killer, 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 killer cross-examination. A podcast by your host, the nationally renowned criminal defense attorney, Neil Rockhind.